Last class we actually completed this second chapter, and now today onward we will discuss on the the third chapter. The third chapter is on the proof, and as the name suggests, on the proof. So the discussion would be like what thing we have to prove, what thing we have not to prove, and what are other things which court will not allow to prove it. Because section 5 to 55, or you can say in the preceding chapter, we discussed at the length with the help of the various cases that what are the relevant fact that you can prove by giving the oral or the documentary evidence. But at the time of the proof, there are certain things which need not to be proved. Like we live in India, this is need not to be proved. The act that in this Indian Evidence Act is applicable in India. This has not to be need not to be proved. So there are so many things which need not to be proved, because that will increase if we think, or if that is allowed, that will increase the burden on the court and the proceeding will be more lengthy. So as a public policy, there are certain things that the court will take in the notice, and that is known as uh, you know uh, judicial notice, you can say. In that case, one has not to be proved. The second situation may be, you know, in the pleading, if we talk about the civil cases or the criminal cases. First, I'm taking civil cases. There is the plaint that filed by the plaintiff, and in the plaint he averred, his claim in different para number 1, 2, 3, etc. So maybe in para number 1 that person A, son of person B, has you know uh, take illegally possession of my property, etc. So in the defense, the written statement has to be filed by the defendant, and in the written statement, para-wise reply has to be given before the court. So in that para-wise reply, if something the defendant admitted, that has not to be proved, because जो admit ही कर लिया उसको क्या prove करना. Because the sole responsibility of proving, as many time I have said, that section 101 of Indian Evidence Act is on the person who approaches to the court. So in the civil cases it is on the plaintiff, in the criminal cases it is on the prosecution side. So prosecution or the plaintiff has to prove, but the things that has been admitted by the opposite side, that mean defendant in the civil cases, and you can say defense side in the criminal cases, these things need not to be proved, because there is no nothing left in that, and there is no purpose served if court will say that plaintiff has to prove it. So these are the something that we will discuss at the time of the proof, that what we have to prove, what we can prove, what we cannot prove, even if that is relevant also. Now this whole chapter third, if you see, it is divided into two parts, and the first part has three subpart. The one is about the fact which need not to be proved, and three sections we will discuss here: section 56, 57, and 58. And the second subpart is fact which parties are prohibited by proving, the rule of Estoppel. Again, three sections: 115, 116, and 117. And the third one is the privileged communication. There's certain communication like between husband and wife, section 122, then the official communication, etc. That is also not allowed to prove. Okay, though that is relevant but not allowed to prove. Estoppel, when the principle of estoppel is applied, the fact may be relevant, but it is not allowed to prove. So this thing uh, that we will discuss in this chapter is not on the relevancy, but it is something after relevancy, whether we are allowed to prove it or not allowed to prove it. And the second portion of this chapter is oral and documentary evidence, section 59 to 78. And in section 59, there is a very cardinal principle that oral evidence cannot be given of the content of the document. And so, the what was the content of the document, that has to be proved only by the documentary. वो document ही लाके दो, for that oral evidence cannot be given. uh, in section 63 you will find as a secondary evidence, but as a general principle it is that oral evidence cannot be given to the content of the document, and the exclusion of oral by the documentary evidence, section 91, 92. These things we will discuss. Now the first I am taking, the first part, all these things I'm talking by the case material. And the first is fact which need not to be proved, section 56, 57, 58. Find section 56 in your Dare Act. It is on the part 2 on proof, chapter 3, facts which need not to be proved. That means the question is not that these facts are not allowed to prove, but because of the public policy, because of the convenience to make the trial shorter. Otherwise, if these sections 56, 57, 58 would not be there, every trial, every proceeding would be much lengthier, because everything you have to prove. Because the burden is on the prosecution and is on the plaintiff side, who approaches to court as per the section 101 to prove each and everything, so that to get the judgment in their favor. Section 56 says fact judicially noticeable need not to be proved. No fact of which the court will take judicial notice need not to be proved. The section is very clear, absolute, there is no exception, that the fact to which the court take the judicial notice, just give me 1 second, the fact to which the court will take the judicial notice need not to be proved. Now the question is that what are those facts to which the court will take judicial notice? One thing we can say, like the seal of our country, the national flag of our country, the flags of other country recognized of government of India. These are the something for which uh, you know proof is not required. The court can take the judicial notice, like gazetted holidays, act applicable. If there is a question that the Code of Criminal Procedure 1973, and the opposite party say that you also have to, you have to prove that this code is applicable. Section 154, the FIR you are talking about, first you prove that this particular statute is in force in India. And so these things, if come, or if someone says that court will take the judicial notice, that this is need not to be proved, already we take the judicial notice. So the section 56 is very clear, lucid, and it cover all the judicial noticeable fact into its sweep. Now section 57 precisely prescribe that what are the fact to which the court will take the judicial notice. And for that there are certain categories. The one is all laws in force in the territory of India. So all laws passed by either our parliament or the state legislature, or bylaws, or even the law passed before our parliament, but they are by any means, by any rules, if they are in force in the territory of India, the court will take the judicial notice, and by virtue of section 56, these you have not to, need not to prove in the court. Second is all public act passed or hereinafter to be passed by the Parliament of the United Kingdom. So this not only cover the past statute of the passed by the Parliament of United Kingdom, even the future hereinafter to be passed. and all local and personal act directed by the Parliament of the United Kingdom to be judicially noticed. See the first clause, that all laws in force not only cover statutory law, even the uncodified law, like the certain portion of Hindu law, Muslim law, that is also covered by one, that if that law is in the force in the territory of India. Then the third is articles of war for Indian Army, Navy, and Air Force. Fourth is the course of proceeding of the Parliament of United Kingdom, of the Constituent Assembly of India, of the Parliament of the legislature established under any law for time being in force in the province or in the state. See, clause 2 and clause 4 talking about the legal, you can say, proceeding and the laws of the United Kingdom, because we have inherited our legal system from the United Kingdom or common law legal system, and that's why many times we need, even if you talk about the law of the tort, most of the law of tort is inspired from that common law principles. And so these two provisions are very much important. If these provision would not be there, then it would be difficult even to prove that law, that this is the law passed in the United Kingdom. But now the question is that when you are talking about that this is the act passed or this is the act of the United Kingdom, and we are making something in reference to that, so you cannot expect that the court, that means the judge who is chaired the court, is known about that thing. You have to provide some book or some document by which that can be verified. And so after these 13 clauses, there are two paras attached to these sections. If you see the first pair I talk about, that in all these cases and also on all matters of public history, literature, science, or art, court may resort for its aid to appropriate book or document of the to the reference. So the document or the appropriate book may be provided so that the court may confirm, but the strict provision of, or you strict liability of proving the fact would not be there, because when you produce the book for the reference, or when you produce the book for the satisfaction of the court, and the court take it the judicial notice, your responsibility is stopped there. The second para of after this is, if the court is called upon any person to take the judicial notice of any fact, it may refuse to do so unless and until such person produce any such book or the document as it may consider necessary to enable it to do. So suppose you take that, sir, in the law of the tort, that my lord, this is the position of in the United Kingdom, and this was the act and something that you want to say. And in that sense, you take that court has to take the judicial notice on this particular thing, and then the court say that please provide us some book or some document on which at least we can verify. And if you are not providing, then the court may take that, sorry, we will not take the judicial notice. So this is something very technical point, even something that as per the section 57, the judicial notice can be taken, but because of your fault, the court may or your court will not take the judicial notice. Then the fifth clause is about the accession and the sign manual of sovereign for time being of United Kingdom of Great Britain and Ireland. Six, all seal of which English court take the judicial notice. All seal. The different, the authorities have the different seal, like you say the Competition Commission of India, the different seal, the UPSC have the different seal. So the various seals that the English court will take the judicial notice, Indian court will also take the judicial notice. The all seal of all court in India, whatever the high court, various high courts or the Supreme Court have the different seal. So for that also you have not need not to prove that सर ये छत्तीसगढ़ हाई कोर्ट की सील है रायपुर की, या ये कैलकाटा हाई कोर्ट की सील है. नो, कोर्ट विल सी इट, और वो उसको करके उसका जुडिशियल नोटिस ले लेगी. एंड all the courts of India established by authority of the central government or the crown representative, the seal of the Court of Admiralty, maritime jurisdiction, notaries public, and all seal which any person is authorized to use by the Constitution or any act. So any seal that is authorized by the Constitution. So maybe the CAG seal, maybe the President seal. So various other seals also, for that also, that is need not to prove that this is the seal of a particular authority. Or any act of the Parliament of the United Kingdom, or any act regulation having force in India. Seventh, the accession to any office, name, title, function, signatories of the person falling for time being in any public in any state, if the fact of their appointment to such office is notified in the official gazette. So whether this particular official office has been chaired by this particular person, like the if you talk about the scheduled caste commission, SC commission, and honorable minister Mr. Vijay Sapla had it, this particular ministry. So if you want to say, or if there is a question that he is the chairing, so the gadget in which the name has been, declared, that gadget you can, the gadget of India, you can produce for that, proving that thing, or you can say for clarifying that thing. After that, the judicial notice will take. Further inquiry will not then you कैसे appointment हुआ, all these things you need not to prove. Only on that the judicial notice will be taken, and when the judicial notice will be taken, the court will deem to prove that fact. That is the importance of this, taking the judicial notice. Then the existence, title, national flag of every state. So like the national flag of our neighbor country Nepal, that double triangle. So for that also, it need not to prove, the judicial notice court will take of every state or the sovereign recognized by government of India, the division of time, the geographical division of world, and the public festival, fast, holiday notified in the office gazette. So the fast, public holidays, everything you have to even produce the gazetted gadget, or the document in which these holidays were there, and the court will take the judicial notice on it. The territories under the dominion of government of India. So what are the territories, like Ladakh is under the India or not? For that also you need not to prove something else. Only the relevant document you will show, and the court will take the judicial notice. The commencement, continuance, termination of the hostility between the government India and any other state or body of person. 12. The name of the member and the officer of the court, their deputies, subordinate officers, and the assistant, and also of all the officials acting in execution of the process, and of all the advocate, attorneys, proctors, vakils, pleaders, and other person authorized by law to appear or act before it. So see, many things this clause 12 cover, like the court, their officers, their deputy, their assistant, and the advocate, vakil, etc. For that also you need not to prove. The relevant document you can show it, and the court will take the judicial notice of it. But if you argue that the court should take the judicial notice and without producing the relevant document, so in that case it's not viable. And the provision is also clear. The second clause attached to the section 57, it clearly say that if you would not be able to produce the relevant document, the court will refuse to take the judicial notice. So that is the consequence. The rule of road, that in the on the road you are walking, and you are walking on the left side of the road, and then a motor car hit you. Now you want to say that you are on the right, or you can say you following the the road practice as per the norms. The opposite party says that no, you have to prove it, that on the left side and in this manner you are talking walking was good. In that case, you have to say that this is the rule of the road, and in that case the court will take the judicial notice. Then the rule of the road on the land and the sea also. So these are the different things, different facts which court will take the judicial notice, covered under section 57. And section 56 club with section 57 makes that the fact that the court will take the judicial notice is need not to be proved. Now the next thing or next provision is fact admitted need not to be proved. And these are the fact that the opposite party, see, we have the adversarial system, and so there are two parties. The burden of proof is also on the person who approaches to the court and want the judgment in his favor. Section 101 of the Indian Evidence Act. So in the civil cases on the plaintiff side, on the criminal cases on the prosecution side. But the the fact which the opposite side, the defendant side, the defense side has admitted, so that fact need not to be proved. Suppose it's about the dying declaration, and the opposite party says that yes, it is dying declaration, need not to be proved. Suppose it is the charges on the opposite party, and the opposite party says that yes, I did this. Okay, I stabbed this person, but that was my not. That was the intention was not to kill that person. So the part of the stabbing need not to be proved because this is already admitted. So section 58 says that no fact need to be proved in any proceeding with the parties thereto and their agent agree to admit at the hearing, or which before the hearing they agree to admit by any writing under under their hand, or which by any rules of the pleading in force at the time they are deemed to have admitted by their pleading, provided that the court may in its discretion require the fact admit to be proved otherwise than by admission. So this section says that the fact in any proceeding, that the party or their representative, their agent, if they admit before the hearing or at the time of the hearing by writing their hand, or which by any rule of the pleading also they deem to be proved. There are various rules of the pleading, and there are certain rules. If you will not, object it, then it will be deemed to prove. In that situation also, the fact need not to be proved, but the power is given to the court because court has to do the justice. So maybe in the situation where because of the technical fault the particular fact was deemed to be proved, but court want again that this fact has to be proved other than the admission, then that authority also have the court. So section 56, 57, and section 58 basically prescribe certain fact that need not to be proved, and in the, you can say, nutshell, you can say that the fact which the court take the judicial notice, and the fact which the other party either admit themselves or through any rule of the pleading deemed to be admitted, these facts need not to be proved in the court. Okay. As per in your case material, there is no case on these sections, and so the discussion on this first subpart, the fact which need not to be proved, is complete it here. Now, guys, if you have any question on section 56, 57, and 58, you please ask me. I'm giving you 1 minute, and then we have the discussion on the second part, that the fact which the parties are prohibited from proving. यहाँ तो प्रूव नहीं करना है. अगले पार्ट में अगर प्रूव भी करना चाहते हो तो कोर्ट विल नॉट अलाउ टू प्रूव. Court will not allow you to prove that thing. Court will not allow you to adduce that fact. Yes, Mr. Viswajit, any question? Srishti?
No, sir.
Okay. So second subpart, I'm taking the fact which the parties are prohibited from proving. Here, the chapter 8 and the provision that we would discuss are section 115, 116, and 117. See, these three provisions are basically prescribes the rule of estoppel. Estoppel word, if you see the literal meaning, means stop. That when you say something, when you act something, and on the belief of that act, if the other party acted, now you cannot change your position. You are not allowed to change your position. And that means that on your declaration, on your written statement, on your oral statement, on your act, if the other party changed their position, his or her position, in that case you are not allowed to give the evidence that will change your position. And that's why these provisions are basically having the rule where the parties are stopped to produce or stop to give the certain fact before the court. And that's why this portion we will discuss, that fact which the parties are prohibited. In the section 115, it is clearly written that the parties will not be allowed to change his position. Okay. Section 115 I'm taking, when one person by his three things: declaration, that will either written or oral statement; act, that means any positive act you are doing; omission, anything that you have to done it but you fail to do that; intentionally, and then the word intentional is also important, that all these things, the declaration, act, and omission, you intentionally caused or permitted another person to believe a thing to be true and to act upon such belief. Okay, this is the principle. If a person by his declaration, oral or written, by his act or the omission, three things it has covered. The first is that you expressly say, like you expressly say that I'm the owner of this land and I want to purchase to Mr. B. Now B on this belief have paid me, पेमेंट भी कर दी, सारी चीजें होगी, and then I said that this is not my property, I'm not owner, this is the property of my father. But during that, father has expired and the property inherited to me. Okay, now I cannot change my position. If the property that belonged to someone else, and if I did that thing, in that situation that would be fraud, that is different situation. Okay, but in the situation where on my act I intentionally caused the other person to believe that this thing is true and to act upon it, then neither this person on whose declaration, act, or omission other party acted, nor his representative, even his heirs after his death also, shall be allowed. That means shall not be allowed. Shall be allowed in any suit or proceeding between himself and such person or his representative to deny the truth of the thing. Now see the illustration. The same illustration that I am discussing, that A intentionally and falsely leads B to believe that certain land belong to A. Now this believe the certain land to be, that may be the declaration उसने कहा हो, लेटर लिख के कहा हो कि ये प्रॉपर्टी मेरी है, या ओरली कहा हो, या ऐसा एक्ट किया हो जिससे अगले को लगा हो कि इंटेंशनली, और अगर उसको लग भी रहा है देन यू हैव टू क्लैरिफाई, नहीं नहीं अभी मेरा प्रॉपर्टी नहीं है, but you intentionally caused or permitted another person to believe. If the you have not caused, even if you have permitted, when you know that the other person is knowing that you are the person, in that situation you have to clarify that no, I'm not the owner. So A intentionally and falsely lead B to believe that certain land belong to A and thereby induce B to buy it and pay for it. ओके, ए ने इंटेंशनली कहा कि भाई साहब ये मेरी प्रॉपर्टी है, and you can buy it. A has B has paid the money to the A, and land afterward became the property of A. Okay, afterward became the property of A means when this deal was happened, A was not the owner. That property may be of his father or other person, but after that this property became the property of A. A seek to set aside the sale on the ground that the time when the sale was concluded, at that time I was not the owner, I have no title. He must not be allowed to prove his want of title. So this is estoppel. Estoppel means a person is stopped in the court to give the evidence when by his declaration act the another person has changed his legal position, or in the language of section 115 says that in the declaration act and omission intentionally caused or permitted the another person to believe a thing to be the true and the other person acted on it, then his representative, that the party or his representative in the any suit or proceeding between himself and such person would shall not be allowed to deny the truth of that thing. Okay, now there are 2 3 cases on this rule of estoppel, and see the rule of estoppel in is our practical life also, it's a very much importance. Many times rule of estoppel became one of the main provision while granting the relief by the court. But before that, going on the cases, these two sections also we should read and discuss, so that the statutory part became complete. Section 116, estoppel of tenant and licensee of the person in possession. Section 116 and section 117 basically have two special rules that applicable in the particular situation. Section 116 is related to tenant, that means landlord and tenant, and licensor and licensee. That means the property is of a one person and the possession is to the another person, both in situation. No tenant of immovable property or the person claiming through such tenant. Person claiming such through tenant means suppose A is the tenant, his son, his wife, his daughter are the person claiming through this tenant. Shall during the continuance of tenancy be permitted to deny the landlord of such tenant had at the beginning of the tenancy is title to such immovable property. So this again is on the public policy. Suppose A is the person and he came to the Delhi for study. He want room, So he approaches to the person B who has a house, and B से उन्होंने एक रूम रेंट पे ले लिया. There was the, you know, rent agreement also, and the relationship between B and A is B is the landlord, A is the tenant. Now at certain point of time, either A or the person through the A, his son or his daughter, because he lived so many years in that room, they say जी B का तो घर ही नहीं है, B has no title. And so this thing they cannot change, because in that agreement, in that landlord, in that rent agreement, B was the, you accepted that B was a landlord. I'm taking the room on the rent and I'm the tenant. Now this position, that B is the landlord and you are the tenant, this position you cannot deny. Okay. The second is about the license, the same thing. आपने डीडीए से लाइसेंस ले लिया एक पर्टिकुलर दुकान का, 10-20 साल बाद में आप कह रहे हो कि डीडीए के पोजीशन ही नहीं है जी, डीडीए मुझे कैसे बाहर निकाल सकता है यहाँ से, डीडीए का तो पोजीशन ही नहीं है. सी द पब्लिक पॉलिसी. आपने जिस टीनेंट से वो मकान, जिस लैंडलॉर्ड से वो मकान लिया, 5 साल 10 साल बाद में टीनेंट कह रहा है कि जी इनका तो मकान ही नहीं है, इनको तो जीपीए में लिया हुआ है. बिकॉज पता नहीं अब आप लोग कहाँ से हो, दिल्ली में बहुत सारी तो जीपीए पे प्रॉपर्टी होती है. जीपीए मीन्स जनरल पावर ऑफ अटॉर्नी. जीपीए एंड एसपीए दो चीज़ होती है. जनरल पावर ऑफ अटॉर्नी, स्पेशल पावर ऑफ अटॉर्नी. तो सपोज आपकी रजिस्ट्री नहीं है, तो आप कहोगे जी ये तो के पास तो जीपीए है, ये तो ओनर ही नहीं है, या वट जो भी आप कहो. तो दैट थिंग यू कैन नॉट डिनाई. And similarly in the licensee, I am reading this second para, that and no person who came upon any immovable property by license of a person in possession thereof shall be permitted to deny that such person had a title to such possession at the time when such license was given. So you cannot deny that the DDA does not have or is not the owner. So ये तो पार्टी नहीं है, ओनर नहीं है, तो मैं क्यों खाली करूं. So these things you cannot deny. It's again the rule of Estoppel. You are stopped to think. Stop means even you cannot give the evidence. अब आप लैंडलॉर्ड के खिलाफ एविडेंस भी नहीं दे सकते कि जी ये देखो जीपीए है या ये इसके तो नाम ही नहीं है. You cannot change that. You are stopped. And so you are not allowed to prove the facts. You are not allowed to give the evidences. So these facts the parties are not allowed. Okay, and that's why that is the title of this subpart. Now section 117, this again contains some specific rule. Section 115 is general, that you can apply to in any cases. Generally, the rule of estoppel applies to the civil proceeding. Okay, but in some uh, criminal proceeding also there is some civil questions related to that. So in that situation also the rule of estoppel applied. But as a general, your answer is that this estoppel will apply to the civil proceeding. And another thing is that rule of estoppel will not apply against the law. आपने कह दिया कि जी ऐसा कानून है, and on that your declaration or act, other party, you cause the other party to believe it true, and the other party on that belief change his position. So in that case, rule of estoppel will not apply. Okay, rule of estoppel cannot be applied against the law, but rule of estoppel can be applied if because of your declaration other person has changed that position. So that thing. Now the section 117 is estoppel of acceptor of bill of exchange, bailee, and licensee. So this covered three things: bill of exchange, bailee, and the licensee. No acceptor of bill of exchange shall be permitted to deny that the drawer had authority to draw such bill, or to the endorsee No acceptor of bill of exchange shall be permitted to deny that the drawer had authority to draw such bill or endorse it. So again, it is in negative connotation. Start with the word no, but if you convert it in the positive, that means the acceptor of the bill of exchange shall not be permitted to deny the drawer authority. आपने बिल ऑफ एक्सचेंज एक्सेप्ट कर लिया, अब आप उसकी अथॉरिटी को चैलेंज कर रहे हो, सो दैट would not be allowed. The second is, nor shall any bailee or the licensee be permitted to deny that his bailer licensed at time of bailment or license commence authority to make such bailment or grant such license. So again, suppose a license has been given, but this license is not of the immovable property. This license is something other than the immovable property. Section 116 is licensor is to the immovable property. So suppose you are the baler. आपके पास एक मोटर बाइक थी, और आप कहीं जा रहे थे, तो आपने सोचा यार मोटर बाइक यहाँ खराब हो जाएगी, चलो अपने दोस्त को दे देता हूँ. सो यू आर द बेलर एंड योर फ्रेंड इज द बेली. Similarly, when you submit some belongings to the railway station or other way, so at your position is baler. In the evidence act you will find it, sorry, in the contract act, and the other person is bailey. अब बाद में वो कहता नहीं, ये तो आपकी चीज ही नहीं है. Okay, similarly is of the licensee. So in that situation, that is also not allowed. Again, the rule of estoppel applied, but these are the some special, like the contract, the general principle of the contract from section 1 to 75, and then there are the five type of the special contract. Okay, so similarly the general principle of estoppel section 115, and these are the special types of the estoppel. Then there is two explanation attached to section 117. The acceptor of bill of exchange may deny that the bill was really drawn by the person to whom it purported to have been drawn. So that thing you can say. And the second explanation, if a bailee delivers the good bail to a person other than the bailer, he may prove that such person has right to then as against the bailer. So if the you have like in the we take again our example, that you submitted your bike to the your friend. So the your friend can give to your father. If your father has this if the your friend prove that your father has the right against you. Okay, so that things is permissible, that if the bailee has delivered that particular belongings, that goods, to a person to which he proves that he has the right against the bailer. Now, come to the cases. See, three, four cases we have on the this fact which the parties are prohibited from proving, or you can say on the estoppel. One case that is very interesting and very important also is uh, on the you know uh, from you can say student life, like one of student, Mr. Satnam Gauda. He applied, he also want to be a lawyer, and so he applied in the admission in the LLB in the Berhampur University. So this name of the case is Satnam, not Satnam, Santan, Sana, Shantan Gauda versus Berhampur. Shantan Gauda versus Berhampur, AIR 1990, Supreme Court 1075, and it is on the page number 131. Now, see the facts of this case, that Mr. Santan Gauda, he was uh, having MA qualification, and in MA examination in 1981, he scored 364 marks out of 900 marks. That means more than 40%. 40% से ज़्यादा थे. And he took the admission in the Ganjam Law College, and this Ganjam Law College was affiliated to Berhampur University. Now, at that time, the eligibility for taking the admission in LLB was that one has to score 40% marks in the graduation. Okay, this person is postgraduate. Now, after that, surely he has more than 40% marks. After that, you know, his admission was confirmed. He, appeared in the pre-law exam and inter-law exam, and finally to the final law exam. At that time, his result was not declared of the pre-exam and the final exam. So 3 years he has spent in the law college. And when he said that why my result was not declared, from the university it was intimated that you did not have the requisite marks to get the admission in the LLB. He represented that I have more than 40% of mark. As per your condition, the 40% or more than 39.5 is the eligibility. The when this representation was not worked, he filed the writ petition before the Berhampur is in the Odisha, so before the Odisha High Court. And the writ petition was also dismissed by the High Court by the impugned order of the 1987, and against that order of the High Court, this appeal is in the Supreme Court. Now, before the Supreme Court, the regulations related to admission to the LLB course were put, and there were two relevant regulations related to the eligibility of the admission in LLB course. One is the regulation 1 in chapter 8, and another is the regulation 10 in chapter 5. Now, if you read the regulation 1 of the chapter 8 says that the qualification for admission to the law courses is as follow, that any registered candidate may be admitted to the degree of Bachelor of Laws if he passes the examination for degree of Bachelor of Arts, Bachelor of Science, Commerce, Oriental Learning, Bachelor of Medicine, Bachelor of Surgery, Bachelor of Science Engineering, Bachelor of Science Agriculture, Bachelor of Veterinary Science, Animal Husbandry, etc., or any other examination recognized by Bar Council of India. Any other examination means like if you talk about our Delhi University Law Faculty, this time the CA, CS, etc., we also recognize equivalent to the graduation, and they can take the admission. So any other examination equivalent scoring more than 40%, scoring 40% or more than 39.5, यानी 39.5 से ऊपर भी होगा, then we university will consider it as a 40% marks in aggregate of such examination or other high degree examination passed after the graduation. Now there is a reservation that provided in case of SC 5% relaxation. For PWD candidate, it is again 5% relaxation. So the first paragraph of this regulation 1 of the 8 is clear, that more than 40%, and this candidate is 364 out of 900, so more than 40%. And so there is no difficulty or ineligibility to the candidate. Then the another regulation 10 of chapter 5, and this is very typical, which prescribe marks for passing the MA, कि किसी को MA का पास मार्क्स कब माना जाएगा. That MA, MCom and MSc examination stated that minimum marks to be required to pass for a candidate is 36%. Like in our LLB, When a candidate score more than 45% of marks in LLB course, he is deemed to be pass. In LLM, the eligibility is 50% marks. And if you remember, in the lower classes, it is only 33%. So for passing in MA, a candidate has to score more than 36%. But if a candidate has in any paper less than 25%, 20 marks, किसी पेपर में 20 marks से कम है, then that marks will not be added into the final exam or final marks. Now this person Sanatan Gauda, in his MA in one paper have 13 marks, and after removing 13 marks, his total marks out of 364 minus 13, 351 marks is less than 39.5%. Okay, so the combined effect of regulation 1 in chapter 8 and regulation 10 in chapter 5, the combined effect is that this person got the admission on MA, and as per the university rule, for passing the MA, the candidate has more than 36% of marks, and in every paper he has to score more than 25 marks. If a candidate has in any paper less than 25 marks, then that mark has to be subtracted in the total marks. Santan Gauda in one paper in LLM, MA, has 13 marks only, and so this is less than 25, so this has to be subtracted in 364, and so his overall marks will be considered as 351. These 13 marks will not be added, and if 351 marks we calculate, it is less than 40%, less than 39.5%, and so he is not eligible to take admission in LL. Now here the court has decided in favor of the Santan Gauda for allowing him to continue his studies as in LLB course on two grounds. One is definitely on interpretation of these regulation, and another is on the rule of Estoppel. On the interpretation, the court has observed that, see, the regulation 1 of chapter 8 that you will find on the para number 6 of the case is clearly on the graduation level, that 40% mark more than 39.5% marks, only the person has the graduation standard. And the person who already was in the academic life 2 more years he spent in the completing the MA, so definitely his academic intelligence and academic qualification would be much better. And so this regulation is that is applicable only for the graduation, would not be applicable to the MA. The second is on the rule of Estoppel, and for that the para number uh, 10, that is important. Para number 9 also is talking about or interpreting these two regulation relating to the eligibility criteria of admission to the LLB. That resolution does not speak of the requirement of marks examination at postgraduate level. I am also of the view that the distinction between graduate and postgraduate made in the matter of qualifying marks is ought to be, since the graduate and postgraduate cannot be treated equally. A postgraduate student has a minimum of 2 years more of academic pursuit to his credit than the graduate before he seeks admission to the law course. Obviously, therefore, they cannot be treated equally, and that is what the University and Bar Council has rightly done. It is the interpretation placed by the university on its own regulation and the resolution of Bar Council of India which is at fault, and not the regulation or the resolution. On the Estoppel, the court said that apart from the fact I find in the present case, the appeal while securing the admission in law college has admittedly submitted his mark sheet along with the application for the admission. The law college has admitted him. He pursued his studies for the 2 years. The university has also granted him the admit card for the pre-law and the intermediate law examination. He was permitted to appear in the SAD examination. He was also admitted to the final year of the course. It is only at the stage of declaration of his result of pre-law and the inter-law examination, first year and second year, that the university raised the objection to his so-called ineligibility to be admitted to the law course. The university is therefore clearly stopped from refusing to declare the result of the appellant examination or from preventing him from pursuing his final course. For all these reasons, I am of the belief that the university is not justifying in refusing to declare the appellant result of the pre-law and intermediate law examination. The appeal therefore succeeds. So in the para number, this is some 2 3 line from para number 11. So in the para number 10, the court has clearly observed, if you apply this, that this Sanatan Gauda want to take admission in LLB. So with the admission form, he also submitted his mark sheets. Now, whose duty is to give the admission? It's on the university duty. It's on the law college duty. They gave him the admission. He spent the 2 years. See, the person whose life at the young life has been uh, spent of 2 years in completing this examination, and now you want to change the position. So when there is no fault from the candidate has applied for admission. He provided all the document for his eligibility. Now it's your duty to decide that whether he was eligible or not eligible. But after 2 years, you are saying that you are not eligible. So that is also the rule of estoppel will apply. And now this position you cannot argue that he is not eligible. Okay, so on both these grounds, the court provided him relief. The another judge in this judgment, he also observed and directed that university has must have very simple rules of the eligibility. They must not be so complex like in this case, so that the candidate will not have the difficulty, because the candidate is thinking in one way and the university will interpret in the another way, and that would be create the difficulty. I'm reading this para number 15, that before parting I would like to impress upon the university authorities to frame the rule in such clear term that it may not require great skill for understanding them. It is a serious matter if a student who acted upon one interpretation of rule and spent a considerable period of his youth is later threatened by a possible alternative construction which may cost him several years of his life. In order to achieve clarity, it does not matter if the rule, instead of being concise, is elaborate and lengthy. So, the rule of Estoppel was applied against the university, and court said that now you cannot change your position, that Mr. Santan Gauda did not have the eligibility at the time of the admission, because there is no fault on the part of the student. He has filled the admission form, and along with the admission form, the requisite degree or the certificate mark sheet also he has attached. And so it was your duty to check it, that whether it is he is eligible or not. But after completing 2 year pre-year examination, pre-law examination, inter-law examination, and even he was admitted to the third year also, At that time, you are saying that was not eligible, so that is not ground. So the interpretation of regulation 1 to the this resolution 8, uh, chapter 8, and regulation 10 to the chapter 5 combined together with the rule of Estoppel. The Santan Gauda was appeal was allowed, and he was admitted to the law course to continue his study. Now there is another case on this Estoppel, and the name of this case is Kumari Madhuri Patil versus Additional Commissioner, AIR 1995, Supreme Court 94. Again, you can listen it, and if you want to note it down, you can do the same. Kumari Madhuri Patil, Kumari Madhuri Patil versus Additional Commissioner, AIR 1995, Supreme Court 94. It is on the page number 120. See, the case is very simple. There are two uh, caste, you can say. One is Hindu Kohli and another is Mahadev Kohli. One is Hindu Kohli, another is Mahadev Kohli. Hindu Kohli caste in the Maharashtra is the one subcaste of the fishermen, and it is comes under the OBC category. Okay, Mahadev Kohli is a tribe even before the independence of India, and these people, Mahadev Kohli, were used to live in the hilly terrain, and they have to their business is basically to collect the minor product from the forest, etc., and they come under the scheduled tribe, ST. Now this person, Pandurang Patil, uh, and his son Laxman Pandurang Patil. So Pandurang Patil and Laxman Pandurang Patil, even the Laxman Pandurang Patil, or you can say Laxman Patil, who was the son of Pandurang Patil, Laxman Patil also in his school days mentioned that he is Hindu Kohli, that means OBC. Now Laxman Patil has two daughters. One is Suchita Kumari Patil, and the second one is Kumari Madhuri Patil. Suchita Patil and Madhuri Patil. Suchita Patil wanted to take, she appeared in the MBBS examination, and she scored, and she want to take admission. When she applied and for the admission, she applied under the category ST. She mentioned in the form that she is a scheduled tribe because she belonged to Mahadev Kohli. When the inquiry was, for that the the caste certificate is required. So she approached. It is on the para number 1, that issuance of such caste certificate as Mahadev Kohli, the sub-divisional officer, Bombay Suburban District, but she was refused to issue the Mahadev Kohli because the documents were checked, and his father Lakshman Patil in his school living was written as a Hindu Kohli. Because there is difference. Hindu Kohli is under the OBC and Mahadev Kohli is under the ST category. Then the Suchita sorry filed appeal against the this decision of the sub-divisional officer for not issuing the scheduled tribe caste, the additional commissioner Konkan division, Bombay. She has applied for the admission into MBBS course, and at the time of her admission was running out, she filed the writ petition. Writ petition against the additional commissioner, that additional commissioner must decide the case, uh, you know, uh, uh, promptly, so that she can get the admission in the MBBS course. Okay. On the writ petition in High Court to direct the additional commissioner to dispose of her appeal, and to further direct the Dean DYC Naik Medical College to permit her to appear for the interview and admit her in the college if she was found fit. So on the showing the writ petition order of the High Court, the she got the admission, and the additional commissioner was deliberating, was in the process of deciding her, appeal. Later on, what happened, that it was not dispute that she filed a copy of judgment in Subhas Ganpatrao Kabde versus State of Maharashtra. That is another judgment in which it is decided that Kohli was held to be the Mahadev Kohli before the additional commissioner and also in High Court, and because of direction of High Court, she was admitted in the MBBS course, and she continues her studies. Later on, her sister Madhuri Patil Madhuri Patil was also, applied for scheduled tribe certificate because she got admission in BDS course. So Badi Behan MBBS and the younger sister was on the BDS, but at that time she applied at the wrong forum. Then she, again approached like her sister to the additional commissioner, and then some inquiry was also done, and then it was found that actually they are Hindu Kohli. A scrutiny committee was set up, and then that scrutiny committee, the evidences was put to prove that they belong to the scheduled tribe. So the scheduled tribe certificate that is given to the various their relative were also adduced, and the additional commissioner has said that the scheduled tribe certificate to these persons have no probative value. The Scheduled Tribe Amendment Act 1976, Mahadev Kohli was introduced as scheduled tribe in state of Maharashtra, and the certificate issued to his maternal uncle Balkrishnan Naik, the maternal uncle of the Madhuri, in the year 1954, and the entries in service record also uh, probabilize the omission to describe Lakshman Patil and Mahadev Kohli, though they as fact belong to the scheduled tribe. In the school register of the plant has enjoyed the status of the scheduled tribe, which provide the probative value. The committee, additional commissioner, and High Court had not appreciated the evidence in the proper perspective before the declining to confirm the social status the appellant as the scheduled tribe, and the High Court ought to have gone into these aspects as was done in the Subhas Ganpatrao Kabde case. It was further contended that Suchita has completed her final year course of the study and Madhuri is in the midway. So the scrutiny committee has found that no, they did not deserve the scheduled tribe because tribe is different. Tribe is not the caste, and Mahadev Koli is a tribe. The person that belong to the Mahadev Koli, this community, they were declared tribe. Even they were criminal trial before the independence, and after that also the president of India has declared them the scheduled tribe. The Hindu Koli is the subcaste, and their occupation is the the fishing, etc. And so these person, their status, knowing the tribal nature, even the tribal people modernize, like in the Delhi University, many tribal people from Manipur, Assam, etc. They are studying, but they did not forget their tradition, etc. So in the scrutiny committee, this whole thing happened, and it was declared that no, their certificate is false, and that has to be seized. At that point of time, this Estoppel, Section 115, was argued on behalf of these sisters. That because they have proceeded their case, and now after providing them the certificate of scheduled tribe, and on that certificate they got the admission. Suchita is at the verge of completing the study, and Madhuri in the midway of his course, and so she both has to allowed on the rule of Estoppel. Now the college and authorities cannot say that they did not have the ST certificate and their admission should not be cancelled. This was contended, and the court, if you have the case material, on the para number 9, the whole para number 9 is important, and the last para of 9 is talking about the difference between Hindu Koli and the Mahadev Koli. Then para number 11, para number 11 say that it's seen admitted that the appellant reside in the Mulant area. In the first instance, the Suchita rightly approached the Tehsildar having the jurisdiction over the area concerned, who refused to give her social certificate of Mahadev Koli. Then she filed the appeal, and the High Court directed the Deputy Commissioner to dispose of the appeal in turn. In that, she gave the some evidences, and the Additional Commissioner decided that she belonged to the Mahadev Koli, and the ST certificate was issued. In the case of the younger sister, uh, you know Madhuri Patil, she actually approached to the wrong forum, and so her position is different from the position of the Suchita Patil. Then the detailed guideline is given, and then on the para number 17, 18, and 19, the finally the court has decided that we have seen that Ms. Suchita rightly made an application before the competent officer within whose jurisdiction her father lives in the Mulant, and when he refused to give the certificates, he filed the appeal, because that is the right of every person. If you want to, get the relief, then you have to approach. So that is not any default on the part of her. She approached the High Court and obtained the direction and gained the admission. It is not disputed that Additional Commissioner was delayed and did not decide as directed by High Court. Instead, they directed the Tehsildar to issue the certificate. So एडिशनल कमिश्नर साहब ने किया कुछ नहीं, उन्होंने डायरेक्ट कर दिया हाई कोर्ट का, जब ऊपर से प्रेशर दिया कि तहसीलदार को कि इनको सर्टिफिकेट इशू कर दो. Thus, he secured a false social status certificate, and order the court were used to gain the admission. The judicial process is made to use of the secure admission. She continued her study, and thereafter proceeding pending scrutiny of her status certificate. No doubt there was a delay on the part of uh, the scrutiny committee in the disposal of the claim. We do not find any record to the scan the reason for the delay. So the court has accepted that yes, there was a delay, but we don't find any reason for that delay also. And then suffice to state that her parents have to put her under a cloud as to her social status, but as seen from the fact of the course of conduct was adopted by her parents to gain admission on the claim, which is now found to be false. Parent misconduct visit their children also many times. Parents का misconduct बच्चों के सामने ही आता है. However, she has now completed the course of study except to appear in the final year as contended by for her. So Suchita has completed whole his course, and she is at the final year examination, and we direct the principal to permit her to sit for the final year examination. So the rule of estoppel was applied, though that was the false certificate. They accepted that does not deserve the status of the ST. They are from the Hindu Koli family that covered under the OBC category, and not the Mahadev Koli that is under the ST category. Both have different antecedent, different character, different the statutory history that discuss in the para number 10. But now at this point of time, the rule of estoppel is applied, and she is allowed to sit in the examination. Direction is given to the principal. But there is one, another direction, that this ST status she will not allows in the future, because her certificate was confiscated. Her certificates were declared to be false because she does not deserve the status of the ST. We direct the principal to permit her to sit for the final year examination. If she has completed the course of study as represented to us, but not with the social status as the scheduled tribe, which was claimed fraudulently and made her admission with the aid of the court order and continues her studies, the delay in disposal facilitated her continued in study of MBBS course. The delay in the process is inevitable, but the factor should neither be considered to be relevant nor to be an aid to complete the course of study, but for the fact she has completed the entire course, except to appear in the final year examination, we would have direct to debar her from prosecuting the studies and appearing in the examination. In his factual situation, no useful purpose would be served to debar her from appearing the examination of final year, and therefore we uphold the cancellation of social status as Mahadev Koli fraudulently obtained by Kumari Suchita Lakshman Patil, but she is allowed to appear for final year examination. She will not, however, be entitled to the future for any benefit on the basis of fraudulent social status as Mahadev Kohli. However, this direction should not be treated and used as a precedent in the future cases to give the similar direction and the same as to defeat the constitutional goal. So she was allowed on the applying the principle of the estoppel as prescribed in section 115 of the Indian Evidence Act to continue her study because the whole course she has cleared. It is only the final year examination. Her certificate was cancelled. She cannot take the benefit of ST in the further, and this direction will also not became the president because it is the order of the Supreme Court. It will not become the president कि ऐसे admission लो और इस तरह से हो जाएगा. No. So it is one time relief that was provided. And in case of the Madhuri Patil, the para number 19, that in case of Madhuri Patil, she did not approach to the competent officer. She appeared to have wrongly gone to an officer who have no jurisdiction. Obviously, she has shown the order issued by High Court in favor of her sister Suchita and secured the certificate and got the admission. Though she is on the midway of her study in the BDS, in the end of second year, she cannot continue her study with social status of Mahadev Koli. So she cannot study as a social status as a Mahadev Koli. But if she is eligible under the general category, yes, she can continue. So a scheduled tribe and the concession which she might have got on that account, if she was eligible uh, for obtaining admission in general candidate, she may continue her study. Therefore, we uphold the cancellation and confiscation of her and Suchita social status as Mahadev Kohli, ordered by the scrutiny committee and affirmed by the court of appellate order of appellate authority, and that the High Court in that behalf, subject to the above modification, the appeal dismissed but without cost. And so, like the Satnam Gauda case, here in the Kumari Madhuri Patil also, the rule of estoppel was applied because the delay was on the part of the authority. But the younger sister approached to the to the wrong forum, and there from the magistrate she got by showing the order of the High Court. This is the fear of the court. आप order लेके आ जाओ किसी दिन law faculty, you saw it, and people will act in because this is the order of the High Court. If you will not act upon it, so maybe there is the case of the uh, you know contempt of the court will be instituted. And on that, something happened. The admission was secured in the law college, in the medical college, after showing uh, the order of the High Court. The additional commissioner were also, after seeing the High Court order, directed to the Tahsildar that issue it is a ST category certificate. So the rule of estoppel is applied in that situation. And so section 115, that is very clear that when a person on the declaration, on the act or the omission, either causing or permitted another person to believe it to the true then he shall not be allowed to deny the truth of that statement. So that is it. And in the many judgments, many cases, the rule of estoppel is applied, and it's really very very important. Section 116 is something that estoppel in case of as a landlord tenant relationship, as a licensor licensee relationship with respect to immovable property. In that case, the tenant cannot deny that his landlord does not have the title of the property, or his licensor does not have the title of the property. Similarly, in the section 117 related to licensor, licensee, here the licensee means other licensee not related to immovable property, bailer and bill of exchange. They also cannot deny to from whom they actually got the title or got the right. So with this, these two sub portion we have completed. One is fact that need not to be proved, section 56, 57, 58, and the second portion is that fact which is not allowed to be proved. So as a this admission, the rule of estoppel, these are not allowed to be proved. The illustration that is provided in section 115, that is also many time in the examination, in the judicial examination or in other examination is asked. And with this today discussion is complete. Another case is also on the estoppel. If you want to read, you can read it. RS Madnappa versus Chandramma. So in the this case is also in the estoppel. If I will find time, so in the next class, maybe I will discuss this case also. And then the second portion we will discuss. The second portion is about before that, the third sub part is privileged communication, section 112 to 119. And MC Varghese versus TJ Poonen, the case on the defamation, we will discuss. The communication between husband and wife, section 112, so that we will discuss. Then the oral and documentary evidence on which the provisions we will discuss, and the case of Rajnarayan we will take. So one more class will be on there, and then this whole chapter will be completed. So on the Monday, we will complete this chapter, and then we will move to the the next one. The next one is about the accomplice, section 113 and 133 versus and 114 B2. So there is two three cases that we will discuss after this provision. And then one class is on the witness and one class is on the presumption. So maybe in the next week we will complete this the whole syllabus, and you will find the time, because up to 18 we have to complete it, so that 10 days period you will get to prepare for the examination. As per the schedule, the examination will be started from 28, but my focus and my thrust would be to complete it even before the 15, बिकॉज 15 का टारगेट लेके चलें तो ज़्यादा ठीक रहेगा. So with this, today class is over. If you have any question, any doubt about these two cases, one is Satnam Gauda versus Berhampur University, another is the Kumari Madhuri Patil versus State of Maharashtra, and third is this R Madnappa. So ये तो डिस्कस नहीं हुआ, बट ये आप पढ़ लेना. See, one portion, you know probably maybe come from this Stockholm. Okay, so don't take it very lightly. Take it seriously. It's not like section 56 to 57. Maybe that sometimes the question may be asked from that portion also, but it's very important as the practical knowledge also, or from the academic point of view also. Yes, guys. Now, if you have any question, yes, please ask me.